Welcome to Foster Swift's Legal Basic video series. I'm Fred Dilley, and I practice litigation law and alternative dispute resolution, primarily facilitative mediation with Foster Swift, Collins & Smith. I'd like to talk to you a little bit about alternative dispute resolution methods and particularly facilitative mediation. We know that 99 out of 100 cases settle. This is true nationwide, it's true in Michigan, and it's certainly true here in West Michigan. The trick here is to try to get cases to settle sooner rather than later, before there's been a great deal of delay and before there's been a great deal of expense incurred by the parties in attorney fees and case costs and other things. So mediation is a process where the parties, through their lawyers, select a neutral to serve as a mediator and conceive a process by which the parties can come together and try to facilitate a collaborative settlement. The process is one that the parties invent and are comfortable with. So it's not like so many things in litigation that are imposed upon the parties. And we also know that settlements that are achieved by parties through mediation, through their own collective efforts, are always more palatable than any solution that's imposed upon them by a court or later by a court of appeals. So why settle cases and why mediate cases? Well, there are several reasons. I can give you at least 5. The first is control of the process. The parties and their lawyers are in control of the mediation process, unlike the court where it's the judge and a jury and eventually a court of appeals that's in control of the case. So the parties design the mediation and they participate voluntarily in the mediation, and they are in control of the process. Certainty of result is probably the best reason to settle cases. There's nothing certain about litigation. There's nothing certain about a trial. A jury verdict is only the beginning, not the end of a case. And so a court of appeals takes over and a case can either be affirmed or reversed and remanded for a new trial. So there's not a lot of certainty that goes with litigation, but there is certainty to any settlement that's achieved through mediation. So certainty of the result is certainly a great plus for any mediation and the settlement that comes from it. Closure is a big feature of mediation. There's nothing about litigation that makes people comfortable, and it's really just the opposite. There's a lot of anxiety and uncertainty that goes with litigation, and so the closure that can come from a settlement, not just legal closure or financial closure, but the emotional closure, the elimination of all of that distress is something that is a great feature of any mediated settlement. Containment of costs is a very obvious benefit of any settlement. You stop the bleeding, so to speak, with attorney fees and case costs, and that's certainly a great advantage, and the sooner you can do that in the litigation process, the better off you are. And confidentiality is the last of at least 5 reasons I can think of to mediate cases. There are just certain things about a public trial and public litigation that is just not in people's best interests. Whether it's a proprietary matter that has to be divulged in a business dispute or deeply personal matters that have to be disclosed in a public trial of a divorce case or a personal injury case that delves into very personal matters. These things are best done in private, and in the confidentiality of a mediation, all of these things can be handled in a way that is very comfortable for the parties and doesn't become a public matter. So there are 5 reasons to settle cases and 5 reasons that mediation is the way to do it. And we really have embraced mediation as a way to recommend to our clients to resolve their disputes here at Foster Swift. So thank you for watching, and if you have any questions, my contact information is on the screen.